are planning to share the PowerPoint of this presentation. So don't worry about taking notes or trying to frantically jot down everything that's on the slides. We are planning to share these slides with you all. So the most important things that you need to know in terms of SAEK testing exemptions will be included in this presentation. Just some things to keep in mind as you're reviewing cases, particularly cases that are SAEK eligible, but also all of your cases that come through your door. Give me just a second. I'm so sorry. I stopped sharing immediately. Let me go ahead and make sure that I share correctly and I'm on the right screen. Okay. And then, sorry for the technical difficulties, folks. I am a little under the weather today, and my brain is not quite operating at its normal pace. All right, let's get started. Okay, so just some introductory matters, things, in terms of housekeeping. So the testing exemptions that we review when it comes to sexual assault evidence kits fall under the Maryland Code of Criminal Procedure 11926. That's E1 through 4. That was passed back in 2020. So these exemptions have been in place for the last 5 years, give or take. And if a sexual assault evidence kit doesn't meet one of the 4 below exemptions, it should be sent for testing. If you have any questions about whether a kit should be sent for testing, you have a couple of options. The first is you can contact me directly. My contact information will be at the end of this presentation. Or you can bring the kit to your local sexual assault response team in your county for review. Either of those options is fine. If you are still unsure after a review at your sexual assault response team, we'll talk about what the protocol looks like for that afterward, a little later on the presentation. So these exemptions apply to all cases, as I mentioned, so not just those who are eligible under the SAEK grant, but any case that comes into your department. So the 4 exemptions, first, as there's clear evidence disproving the allegation of sexual assault. The second, that the facts alleged could not be interpreted as a crime. The third, that the victim declines to give consent for analysis. And finally, that the suspect's profile was previously uploaded into CODIS as a convicted offender for a qualifying offense, and the suspect pled guilty in the current sexual assault case. And we'll talk a little bit more detail about each of these 4 in a moment. So unfounded baseless, the definition is really simple, but we are going to talk about some examples of what is and what is not unfounded baseless, as well as unfounded false. So unfounded baseless is the definition is again a simple one. A reported sexual assault does not meet the elements of a crime. So even if the account as provided by the victim and in the report were to be true, it does not constitute a crime, what is alleged. Unfounded false is that a report can only be determined to be false if the evidence from the investigation establishes that a crime was not either completed or attempted. And this requires a thorough investigation by the local jurisdiction. This is not just an assessment of the victim's story only without reviewing further evidence. This is a thorough investigation conducted by the agency to determine that there is no case and that it is false. So things to keep in mind regarding unfounded, baseless, or false classifications. Some of the following examples are ones where a case could not be classified as false or baseless. So there's insufficient evidence to prove that the sexual assault happened. Insufficient evidence does not mean that it is false or baseless. It just means that either further investigation needs to be done or it needs to be sent for testing. The identity of the suspect is known. A suspect admitted to sex with the victim but maintained that it was consensual. The defense of consensual sex by a suspect does not constitute that the victim's claim is either false or baseless. Suspicions by law enforcement that the report is false, again, without that further investigation. the victim changes their account of events. For those who have had the opportunity to attend MCASA's neurobiology of trauma training or do any trauma-informed interviewing training, you may be familiar with some of the ideas around how the neurobiology of trauma can affect the way that a victim may remember a sequence of events or may remember that a crime occurred, and how that may change at a later date, and that does not constitute their claim being false or baseless. And then finally, one that we see quite a bit, which is that the state's attorney's office determined that a crime had been committed but declined prosecution. Just because prosecution has been declined does not meet the exception of unfounded or baseless. Speaking of the victim, so if the victim declines consent for analysis, this is an exemption to testing. So in the victim in the case, either upon the collection of the kit, so a Jane Doe or anonymous, or at a later date during the course of the investigation, requests either to remain anonymous or that their kit not be tested. So when a kit is collected as Jane Doe, this victim is stating that they do not wish to report the assault to law enforcement, engage with the criminal justice system. They may choose to change their mind at a later date and decide to engage with the criminal justice system. If they do choose to do that at a later time and report the assault to law enforcement, the case should be reclassified as reported and it may become eligible for testing at that time. Things that are important to note about this particular exemption. Some examples which the case may not be classified as victim declining consent for analysis. The victim has requested that the investigation of their case stop. So this does happen where a victim may say, I no longer want law enforcement to investigate my case. What should happen at that point in time if that victim has initiated the conversation regarding and stopping the investigation of their case? They should be asked what they want done with their kit. If they still want their kit tested, that kit should be tested. If that question was never asked, perhaps working with MCASA to contact the victim and determine what they want done with their kit at that point in time. Because they may not want to hear from you as law enforcement, but they may be willing to speak with MCASA. But we do need to determine what they want done with their kit after the investigation stops. Also, one that we see quite a bit, if the victim is classified in a report as uncooperative, non-responsive, or not reaching out to law enforcement to talk about their case, or refuse to speak with law enforcement about their case, that is not declining consent for analysis. That is simply not wanting to engage with the law enforcement system or preferring to take some distance from the case before responding to law enforcement. That does not mean their case should be closed and their kit not tested. If the victim requests that their investigation stop, like I said, the law enforcement should inquire what the victim wants done with their kit. They should be advised that if they don't ask that the kit not be tested, it will be tested. And unless that request happens, the kit will move forward. They should also ask what level of contact the victim wishes to have with law enforcement regarding the testing of their kit. So if they agree that they want their kit tested, they should be asked, do they want to speak with law enforcement if when the kit comes back from testing? Do they only want to speak with law enforcement if the kit comes back with a DNA sample or a positive CODIS hit? And who do they want to provide that contact? Do they want law enforcement to reach out to them? Do they want a victim advocate to reach out to them? Or do they want to hear from both law enforcement and a victim advocate regarding the status of their kit? And just to go over these basics, I feel like we should all be aware at this point in time, but several years back, we passed a law that's now in Maryland Criminal Procedure 11929, that you cannot present a victim of sexual assault with a written waiver that relieves law enforcement of their obligation to the victim, which can include, but is not limited to, defining the scope of the investigation of the case, limiting prosecution, or limiting the victim's right to file a private right of action against the law enforcement agency. So in other words, you cannot present a victim with a written waiver to stop the investigation of their case containing any of the language that's in 11929. Additionally, I feel like most people should have seen, but if you have not, I'm happy to redistribute an FAQ guidance document that went out from the SAEK committee in January. We also strongly discourage the use of verbal waivers, where law enforcement or the prosecutor's office takes the initiative to approach a victim to discuss whether their case should continue. Um, Obviously, this is not currently in the statute. However, we do feel and we do have issued guidance that that behavior is inconsistent with the intent of the statute that we passed. So in all cases, a victim, if they want the investigation of their case to stop, they should be approaching law enforcement. It should not be the other way around, whether that is written or verbal. Suspect already in CODIS. I feel like this is straightforward, but a little difficult to understand unless you're reading each point of the exemption. So cases in which the suspect is already in CODIS as a convicted offender, the identity of the suspect is not disputed, and there has been a final conviction where all appeals have been exhausted. So if there is a case where the offender in the case is clearly the offender, we know this is the offender, they are already in CODIS due to a prior conviction, and there have been no further appeals on the case where the conviction happened, or the suspect profile has been collected for entry as a convicted offender for a qualifying offense in CODIS, and the suspect has pleaded guilty to the offense that led to the sexual assault evidence collection kit. Excuse me, folks. Obviously, I'm a little under the weather today. So start review of SAEKs. So for those who have never attended before a sexual assault response team coalition meeting, there is a sexual assault response team coalition, I think, in almost every county in Maryland at this point. For kits collected on or before May 1st of 2018, a SART review must be conducted for all SAEKs that are already not being submitted for testing. So in other words, if you have a kit in your possession and you are not sure whether it should be tested, you have not made that decision based on the previously written reason for closing the case and not testing the kit, is not sufficient and that you want to test it. If that has not already happened, you should be reviewing the case at your local sexual assault response team meeting. A SART case review requires a vote from each of the following parties, and these are folks that are involved in these types of cases, and it's also mandated by statute. So a forensic nurse examiner, a local law enforcement agent, a representative of the county state's attorney's office, a representative of your local rape crisis center, a representative of MCASA, and if available, a victim's rights attorney and a representative of the local crime lab. For cases that were collected on or before May 1st of 2018, if the SART cannot reach a unanimous decision as to whether the kit should be tested, the SAEK committee has to be contacted to conduct a secondary review of that case. So in other words, you would reach out to me as the counsel for the SAEK committee. Let me know we have this case from prior to May 1, 2018, where a unanimous decision cannot be reached, and we need a case review from a secondary team at the state level. What will happen is I will reach out, create an identical composition of the local level SART with different representatives from agencies across the state, and we will then review the case and provide you with a response as to whether we believe that the case should be tested. For kits that are collected after May 1st of 2018, the SART may elect to review any case, either where a decision has not been reached whether to test the kit, or if there's disagreement whether to test the kit. And in addition to a SART making the decision to review a case from after May 1st of 2018, a victim or a SART member agency has the right to request that a SART review the kit, and that review must be conducted. Where the request has come from the victim, the SART should endeavor to conduct the review and provide the result of that review to the requester within 90 days of that request happening. The decision whether to test a kit for kits collected after May 1st, 2018 may be reached by majority or unanimously. So in other words, if it is not a majority, if it's not a unanimous decision on these kits after May 1 of 2018, as long as it is a majority, that decision can be reached. However, if there is no majority on these cases, the local SART, you can also request that the SAEK committee create a secondary review team and review that case as well. We will review those in addition to all cases before May 1st of 2018. I know I probably talked a little fast, and I'm always happy to answer questions about this particular issue, either during this presentation today or after the fact. This is my contact information here at the top. That's my email. That's my office phone number. If you have any points of clarification in terms of who runs your local SART, how to get in contact with them if you do not already attend those meetings, or any protocols around SART meetings, Laura Jessic is your best contact. I have listed her email and her phone number here. Like I said, I'm happy to answer questions now or answer questions via phone or email later on. Excuse me. Okay, and that is the end of the presentation. Thank you so much. Again, happy to answer any questions you all may have.
While we wait to see if anyone has any questions, I did put various resources in the chat. So the FAQs on these types of the testing criteria, a testing flow chart, information on the ban of waivers, and also the guidance for SART case reviews. So those links are all available to you as well. I saw Carissa, I don't remember if you mentioned this, but I do want to add one point of clarification. For the required kit reviews for cases older than May 1st, 2018, that applies to not only if a decision hasn't been made or if law enforcement has made the decision that the kit will not be tested. So that decision to not test a kit does require a review process as well, even if that decision to not test the kit is because it is deemed to meet an exception. Again, that review does need to take place. And that's for all cases older than 2018. Is that correct, Carissa?
Yes, that's correct. And thank you for that point of clarification.
I'm not seeing any questions in the chat. I'm sure we can hang around for a second, see if anything does come through, but I don't think we're going to hold you guys here for another 30 minutes just to hold you here unless anyone has any questions. So if not, you're free to leave. Otherwise, we'll hang out and answer any questions. Yes.
Laura, this is
Chief
Chief Allen
Downey.
with the Berlin Police Department. How are you doing today?
Good. How are you?
I am well. Asking the same question. We are the ones that house 39 Jane Doe kits dating back to 2009. So in our situation, again, we wouldn't be doing anything or submitting anything, correct?
Correct.
Thank you.
Not a problem. So we will still collect annual data from you in the sense of the annual report that the SAEK committee issues, just to maintain that you haven't collected any new kits during the previous fiscal year, regardless of whether they're anonymous. So we will request that reporting, but in terms of SART meetings or determining kit eligibility for testing, if they're anonymous and there's no movement towards them not becoming anonymous, then there's no further things that you would need to know in terms of this presentation.
Thank you.
Any other questions? I thought I heard somebody else speak, but I'm not sure. Okay. Like I said, I'll just wrap this up. Everyone has Carissa's email. Carissa, if you want to put it in the chat so people can copy and paste, I'll put mine in as well. So if you have any questions that come up after this meeting, you can feel free to reach out to either of us about SARTs or testing kits, and we'll be happy to help. We'll send around the recording as well as the slides to everyone that was registered for the meeting as well. So if you need to refer back to it, you can. Other than that, we'll go ahead and wrap it up for the day and let you guys go. So thanks for joining us.
Thanks, everyone.